The attorney-client privilege. The reason for creating the attorney and client privilege is to encourage people to seek legal assistance. We know under this privilege, the attorney cannot disclose the contents of confidential communication between the attorney and the client. So this way, we want to grant this privilege because we want to encourage people to seek legal assistance. We know legal assistance is very important. It's a very important part in making sure we have this fair administration of justice. If people do not seek legal assistance, if in many cases, if people do not have the assistance of the attorneys, and then they could not really handle the legal issues properly, so their interest would not be properly protected. But of course, if you say people can go to the attorney, can discuss the attorney their legal issues, but if the attorney turn around can really disclose the contents of the communication, and then people would not feel confident in going to attorneys to seek this legal assistance. So to encourage people to seek legal assistance, we created this attorney-client privilege. Under this privilege, the attorney cannot, of course, the court would also not compel the attorney to disclose the contents of a confidential attorney-client communications. That is the rationale for creating this privilege. But we need to know the scope of protection of this privilege is limited to communication. So what is protected is only confidential communications between the attorney and the client. By emphasizing this communication, what we want to express is really this: what the attorney, if something is not communication, and then that is not protected by this privilege. So, for example, what this lawyer, if we have this consultation, what the lawyer actually observes is not covered by the privilege. For instance, the client's appearance, the client's clothing, the client's mental capacity, and whether the person could communicate properly, or so on and so forth, whether the person suffers some like a mental disease. These kind of things are things observed by the attorney. So they are not considered communication. So this observation would not be protected by this privilege. Just to give you one example, if suppose we have this murder case under police investigation, and then if this suspect, or in this murder case, and he went to attorney, and then he actually confessed to the attorney that he actually committed this murder, the attorney cannot disclose this communication to anyone. The attorney cannot really call the police or call the prosecutor saying that I have a client just come to my office, and then he has confessed to me he committed this murder. The attorney cannot do that because we have this attorney-client privilege. The attorney cannot do that. Of course, if the prosecution learns this suspect actually went to the attorney's office, and then the prosecution's office cannot really compel the lawyers to disclose the contents of the communication between the attorney and the client. However, if the police actually suspected the person who went to the lawyer actually was the murder suspect, but police wanted to know how this suspect looks like. and what is the suspect's appearance and clothing. And then if the police would require this kind of information from the attorney cannot invoke this privilege to decline to answer. Because his client's appearance, his client's clothing, those things are not communication. So the attorney cannot invoke the privilege to refuse to answer those kind of questions. So that example would demonstrate what we mean by this privilege protects only communications. If something is not communication, that is not protected. So basically what we are saying is that is only this privilege only protects whatever the client actually communicates to the attorney. If it is not something that is not communicated to the attorney, and then that is not going to be protected. That is a very important point for us to know. Another important issue is this: how the attorney should handle the physical evidence of a crime. Suppose we have this murder suspect and who comes to this attorney's office, and then he actually he actually confesses to the attorney he actually committed this crime. We know the attorney cannot disclose this communication because this is a communication between the attorney and his client. But what if this suspect also takes out the murder weapon he used in committing the crime, and then he would leave this murder weapon in the attorney's office? And then in that situation, this attorney would come into possession of criminal evidence. So how the attorney should handle this physical evidence of a crime? On this issue, the law in all the states actually require the attorney to turn over this physical evidence to the authorities. Because we know this privilege protects only the communication. But if the attorney would come into the possession of a physical evidence of a crime, and then the law requires the attorney to turn this physical evidence over to the authority. But of course, the law actually differs on whether the attorney should also disclose how he actually comes into possession of this physical evidence. Meaning is, and the law in some states would require the attorney to disclose the source of this physical evidence, but the law in other states would not require the attorney to disclose the source of this physical evidence. So that part, you don't have to worry about that part, but it is important for you to remember the law in all the states require that physical evidence of a crime must be turned over to the authority. This law actually makes sense, and because if this criminal evidence is physical evidence is not is out there, if a crime is committed, and then if we have this physical evidence, if this suppose that the suspect committed the murder, and then he just dropped this murder weapon, say, in a wooded area next to a river. And if that physical evidence, this murder weapon is over there, we know the police would have this opportunity to discover this physical evidence. But if the suspect would bring this murder weapon to the attorney's office and leave it in the attorney's office, and then if the attorney would not really turn this evidence over to the police, and then the police would never be able to find this murder weapon anymore. So we know in that case, and then the attorney would play the role of concealing criminal evidence from the police. That is not really good for the criminal investigation. That is also unfair because oftentimes, the attorney probably would be the first one to learn this whereabouts of this criminal evidence if this suspect would choose to disclose that information to the attorney. And so if the attorney would always collect this physical evidence and then put it in the attorney's office and then lock them away, and then the police would never be able to find this criminal evidence. So on that account, we are saying the attorney cannot really keep this physical evidence. The physical evidence must be turned over to the police. But of course, we know here we have this difficulty, and then if the attorney, if the suspect only tells the attorney, I actually dropped this motor weapon in a wooded area near a river, this communication would be protected, and then the attorney can choose not to go there to retrieve this weapon. And then in that case, the attorney actually is not obligated to disclose anything. But if the suspect actually brings this motor weapon to the attorney's office, and then the suspect wants to leave this motor weapon in the attorney's office, and then the attorney actually is in a very difficult situation. If the attorney really takes this motor weapon, and then the law would require the attorney to turn it over to the authority. And if the lawyer would do it, maybe the suspect, the client, would think that is really an act of a betrayal. And if there's a motor weapon in your office, you're my attorney, and then you turn this weapon to the authority. But nonetheless, the law indeed requires the attorney to do that. So under the circumstances, the attorney probably, a possible course of action for the attorney probably is the attorney should tell his client, if you leave this motor weapon in my office, and then by law, I'm obligated to turn over to the authority. And then, of course, the attorney would, maybe the suspect would say, oh, if that is the case, I'm going to take this motor weapon away with me. But in that situation, the attorney must also advise his client to destroy criminal evidence is a crime, because according to the law of all the states, concealment and also destruction of criminal evidence is a crime. The attorney should also inform his client of the law. But beyond that, probably there's nothing the attorney can do. And then the attorney would have to inform the client, if you leave the murder weapon with me, I have to turn it over to the authority. If you want to take it away, you can do that, but I also have to inform you, I also have to tell you to destroy criminal evidence is a crime. So we know in this situation, the attorney could be in a difficult position, but nonetheless, that is what we have as to how the attorney needs to handle this physical evidence of crime that comes into his possession.